question is whether a loan must be represented by book dates from its inception under Section 185 of the Companies Act 2013. For a loan to be represented by book date, is it required that from its very inception, the book date has to be in the nature of the loan to the director? This is a question. Under the old Act 1956, there was a Section 296 provided an express clarification stating that Section 295 shall apply to any transaction represented by book date only if such transaction was from its inception in the nature of loan or advance. This meant that unless a book date was originally structured as a loan or advance, it would not attract the prohibition under Section 295. Transition to Companies Act 2013, with the enactment of the Companies Act 2013, Section 295 and 296 were merged into the present 185, which deals with the loan to directors and related entities. However, the specific clarification found in Section 296 of Old Act 1956 is absent in Section 185 of Companies Act 2013. This change has led to a broader interpretation of what may constitute a loan represented by a book date. Interpretation under the current law, that is 2013 Act, as per the current legal understanding and corporate governance practices, it is not essential that book date must be a loan from the very beginning. It is not essential. A book date initially created due to sale of goods or services or normal credit terms may be treated as a loan at a later stage. If the terms are altered or unaltered, if those terms are altered or unduly relaxed in a manner that provides an unfair or non-arm's length advantage to the director, a book date initially created due to sale of goods or services on normal credit terms may be treated as a loan at a later stage if the terms are altered or unduly relaxed in a manner that provides unfair or non-arm's length advantage to the director, then it will be treated as a loan at later stage. So the key indicators that book date may be treated as a loan. So what are the key indicators? One is extension of credit period. If the credit period is unusually extended beyond that what is offered to the other customers without commercial justification, so it may suggest as a deep loan. And no efforts for recovery. If the company does not pursue recovery from the director beyond the normal credit period, it could reflect intention to defer or forgive prepayment, again amounting to constructive loan. Another one is preferential treatment. If the director enjoys the terms that are more favorable than those offered to unrelated parties, it can be considered as a loan in disguise. Loan in disguise. Another one, conversion of sale transaction to a loan. A routine book date can transform into a loan if the company modifies the terms later to allow installments, moratorium, or non-interest bearing terms, especially for the director. Judicial and regulatory views. Although Section 185 does not specify the from inception condition, regulators and tribunals examine the facts and intention behind the transaction. They look into the board resolutions and or internal notes, credit policies, comparative treatment of other debtors, financial statement disclosures. So now the conclusion is, while under 1956 Act, a book date had to be a loan from the inception to attract restriction. But under new Act, 2013 Act, even transformation of a book date into a loan later due to relaxation of terms may bring the transaction within the scope of Section 185. So the transformation of a book date into a loan later due to Relaxation of terms may be bring the transaction within the scope of section 185. So hence the companies must exercise caution in allowing extended credit or relaxation of terms to the directors. Let they unintentionally violate the loan restriction provisions under the Companies Act 2013. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe and hit bell icon so that you will not miss any of the latest updates. Thank you.